Today, we're going to work through what a lot of people enjoy about asset protection and some of the tax cases, and that's what people do in terms of protections, what sometimes people get too aggressive with, and how the courts react. It's more of a case by case review that shows how far people will go and how far courts will go. I mean, how far the courts will go in enforcing their judgments. So we're going to look at the judicial perspective, and as a preview, the judicial perspective you always have to keep in mind with respect to asset protection and structuring, because these judges go through a case. They may spend a year or 2 years over a case and even a trial. And when there's a judgment, they really intend on enforcing that judgment and collecting that money. That's kind of what this seminar entails. It talks about what they do to actually create a collection on the judgment that they render. We'll go through some background with protective entity, LLCs, both formation issues, where to form them, what's the current status of single member LLCs and how that may be a weakness. We have a fairly recent case on this idea of, well, even if it's not a single member LLC, should it be treated as one? We'll take a look at some of the foreign LLCs, and then we'll end with the trusts and the cases associated with the trust, both domestic and international. Some of the cases, it's surprising where the courts land, but it all comes back to how they view themselves in the judicial process and in the collection process. So this is just a general slide on asset protection, and it does go a long way with respect to predicting how courts will react. I mean, if you view asset protection as kind of something that you might get to after you get into a dispute or litigation, it's not that. You're not going to hide assets. You're not going to avoid the IRS after you've had some kind of problem, where even if you likely will have a problem, and you move something out, you're going to be viewed as having intended to avoid that creditor or that future creditor, and that's a problem. You'll see that the courts are very, very happy to uphold protections that occur as a plan long before the clouds start to come in. Asset protection that which translates to what these cases involve are, were assets titled properly, for instance, in husband and wife. Do the assets, are they entitled to an exemption? In other words, if we get them into the right jurisdiction, is that asset in this jurisdiction exempt from creditors, like life insurance or the house, where it doesn't really matter what the case involves or what the collection action, exactly how it plays out. This asset is not available to creditors. Those are exempt assets. And then we'll get into trust. The way trusts work from an asset protection and a structuring standpoint is that, unlike entities, which is the next item there, like LLCs, trusts involve the actual changing of title of an asset from an individual or an entity to a trust. So when we change the title, what happens is we have a new party. A lot of people ask, well, are they going to break through my LLC, or are they going to break through my trust if I have a problem? Well, a lot of times, if it involves an individual grantor or founder of an LLC, they're worried about a case, for instance, a physician who gets sued on a malpractice matter. That case is against the physician. So the physician will have the interest in the LLC in general. But the physician, if the physician did the trust planning, the physician does not own the interest in the trust, does not control the interest in the trust, and is not a beneficiary of the interest in the trust, depending on the type of trust. So what happens is that's not a party to that action, and that's a much stronger situation. What happens with trust is we divide title, we fund the trust, and then a trustee operates the trust, but the trustee cannot benefit from the trust. The trustee is kind of a hired, it's like an employee of the trust. And then you have separate beneficiaries who don't control the trust, but benefit if there's a distribution, etc., from the trust. And we mentioned LLCs. LLCs offer what's called charging order protection. It's not so much protection in and of itself. It's comparatively stronger. So if someone owns stock in a corporation and they're sued, that stock is available to creditors. So they just take the stock like any other asset that the creditor might have, that the debtor might have. An LLC is a little different depending on the circumstances. If someone sues the owner of an LLC, they can't just take it like a corporation or any other asset. They sue the LLC and they can get a lien on the LLC just in case there's a distribution of profits or available cash from the LLC to the debtor. The creditor can take it. But if there's no distribution, there's nothing available to the debtor. So kind of the moral of the story is we started at the beginning here with courts tend to enforce statutory protections afforded to a business entity. A lot of people ask, well, what's a basic form of asset protection? The corporation's a basic form of asset protection. It's not viewed as that today. So when we start a corporation, we fund it with assets, and that corporation ends up doing business, and the corporation has creditors and issues, and may have property that someone could fall down on, etc. Well, the corporation is the insulation from the owners. So if you own stock in IBM, just the same as if you own stock in a small S corporation, you're not liable for what happens in the operations of IBM or the gas station that's in the S corp. That's asset protection. I mean, that's in the statute. It says if you properly form it and fund it, the debts of the corporation are not the debts of the owners. And that's your basic asset protection. Why we involve LLCs is from the outside. Inside, the corporation is very protective. Outside means if an owner is sued, is that owner's interest in the entity, is that owner's interest in the corporation available to the creditor? With a corporation, it's completely available. With an LLC, the LLC offers this charging order protection so in general, the plaintiff can only take a lien on the LLC interest, and if distributions are made, they would get that, but nothing else. And then, of course, you have your instances of misuse and fraud involving an entity. And if we misuse the entity or we treat the entity as if it doesn't exist, a lot of courts will also treat it as if it does not exist and allow the creditor to either get into the entity from the outside or make the owner liable for activities of the entity. So you always want to avoid that. In Florida, it's fairly, it takes a little bit of work to actually mess up the entity. So it is more protective in Florida. You can get caught with the court looking through your entity, but it's difficult. We talked about this outside asset protection, which the corporation does not afford its owners, but the LLC does. That's this economic interest. So if a plaintiff comes in and sues the owner of an LLC, they're going to take a lien, and that's an economic interest. So if there's a distribution, it comes out. If no distribution, no benefit to the creditor. In short, what happens is you have your LLCs and it's protected. We'll go through some of the weaknesses that the courts have, so in some instances created, or in some instances broadened. But essentially what happens if it is a protective LLC and a creditor comes in and sues an owner of the LLC and gets the lien, the creditor is really not interested in a lien. As you can imagine, you have this long drawn out litigation, plaintiff wins, becomes a creditor. They really want to just get paid. So the lien, the limitation, discharging order limitation to a lien where they can't take the LLC interest, it spurs settlement is essentially what happens. That's the protection. It's a barrier that spurs settlement of the underlying case. And it is very effective in practice. The way that the statutes work is some statutes say, well, it's the exclusive remedy. Because what happens is the courts get upset. They want to collect. They want to help the plaintiff collect. And they'll be in a state where it says a plaintiff can only get a charging order on the equity. And the court said, well, is that the only remedy? Nothing like this is in the statute. It's just that it's clear. It says that the remedy is a lien. But the bankruptcy court started looking at, well, it didn't say that it was the only remedy. So a number of states, I think about 22 or something like that at this point, have added it's the exclusive remedy. And for instance, Delaware, Nevada, South Dakota have added language that says even if it's a single member LLC, a charging order is the exclusive remedy. And you want to, those are the states we want to use for single member LLCs if we can. These are charging order remedies. A lot of people are unaware that the LLC, that this idea of just being able to lien an LLC interest came from prior law. It came from partnership law. And there was a transition from partnership, which no one wants to do because the actual owners are liable for the internal operations of the entity. And if it's a limited partnership, the general partner is liable. And so we've gotten away from that substantially. Now we use the LLC, which has the inside protection that nobody's liable for internal operations generally. And you know, we also have the partnership idea of this charging order where if someone sues an owner, they can't get to the actual voting interest, you know, the equity itself. They can just take the charging lien, and that started with partnerships. Here's a slide on the idea that the LLCs combine the inside and outside asset protection, and also offer a lot more flexibility. Now, of course, the negative side of the flexibility is that unlike a corporation, we have pretty much standard bylaws that follow the statute. It's shares, it's an issuance. You may have a shareholders agreement that's fairly straightforward. With LLCs, you make your own rules. And I can't tell you how many people have come to our offices having hocked together. We have one now actually in litigation, having hocked together an operating agreement. And when you ask them what things say, they actually don't know. They actually don't know. Those are the rules though. If you get into a dispute, those rules are going to govern. And we've had a number of, especially these 5149s or these 50-50 ownership LLCs where people kind of pulled something off the internet. And I mean, it's just a complete mess. It's just a complete mess. When we choose our LLC, a lot of times we look at the Uniform Act, which is the revised Uniform Limited Liability Company Act. A lot of the revised act is not very protective, so we often stay away from the states that use the revised act. These are the factors we kind of look at a lot of times. Does the statute allow for foreclosure? In other words, if I get a lien on the LLC interest, can I foreclose it? Can I take it? Obviously, you want to stay away from that. Does the LLC jurisdiction allow for protective titling? Very much an overlooked issue. So if we're in Florida and we create a multi-member LLC with husband and wife, we would put them together at the top as tenants by the entirety. So we can have tenants by the entirety, which creates a lot of protection for husband and wife. Own the LLC. That avoids even the charging lien if both spouses are not subject to the suit. If husband's sued and it's a tenancy by the entirety asset, there's no ability to reach the asset at all or lien it. And then, of course, if you've seen the courts start to chip away at protections in their LLC statute, we want to stay away from those jurisdictions. One of the last factors we look at is, does the state look and respect the internal affairs of other states? So Florida, for instance, says if we are ruling on another LLC, an LLC form, for instance, in Delaware, we're to look and follow the internal affairs of the other jurisdiction. The suggestion is that if you form a Delaware LLC or you form a Nevada LLC, that Florida will respect that entity, the internal operation of that entity. It hasn't really worked like that. Unfortunately, the internal affairs statutes in cases around the country are a little ambiguous. They do suggest that they'll follow the rules of the other state in their court. This is the internal affairs doctrine, but it's kind of hit and miss. And factors are the statute of limitations. You know, which jurisdiction has the statute of limitations on fraudulent transfer that's short? You know, how do we view insider transfers, and then which charging order statute, which state do we want to use? And we choose that, and hopefully we can get that. If we're crossing states, we can pick a state if they make a ruling on that LLC, that they'll respect the internal affairs of the LLC. One very illustrative case was a 2015 mortgage crisis case where Sabrina Barber, who had borrowed, I think it was $65 million, defaulted on all kinds of stuff, was in the middle of a chaos. At that point, it's what we call a fraudulent transfer. So her transfers aren't really going to work anyway. She funded a Nevis LLC, an offshore LLC, and it really wasn't going to work for practical purposes because she was already in the middle of all kinds of problems. But the way the court handled it may be illustrative. So she's in court now. Wells Fargo is trying to recover its loan, and she's funded these Nevis LLCs. She's also done a lot of other things that really didn't make a lot of sense, like move assets out of her homestead in Florida. Actually, she probably would have been able to keep her homestead. But the case is illustrative because the court didn't take what I thought was kind of the obvious tack, which was, okay, Sabrina, you're not allowed to move things once you get into litigation or you understand you have a problem. So what we're going to do is we're going to bring those assets back into the exposed situation. In other words, into your name, and then we'll allow for collection. They went further. They said, well, we understand that the assets were moved to a Nevis LLC. We're not going to bring them back. What we're going to do is say that Nevis LLC is basically a Florida LLC. I'm not sure how they don't really get there in a sequence of legal precedent. So it became a Florida LLC. Florida does not protect the single member. This is before the new statute, but I'm not sure it would have protected her anyway. And so we're just going to take it. Instead of saying, well, it's a fraudulent transfer, we're going to bring it back. They just turned a Nevis LLC into a Florida LLC, which is illustrative. You don't want to get involved with not having planned and then just starting to shove assets into these different vehicles thinking it's going to work. It's not going to work. There's an interesting case that came around the same time, just before it, actually, called Sargent, where, and we'll hit that later because it actually now has a conflict that was resolved in Florida. But Sargent said, well, I realize we have litigation, and Sargent won the litigation. This, by the way, this went on for years, this litigation. And you want to now collect, Sargent, against Al-Salah. But what Al-Salah says, well, the statute basically says that Sargent has to get the certificate of my corporations to collect the assets in those corporations. It was corporations and some foreign style entities. So the certificates were moved offshore, and the court said, you know, that's true. You have to, you can take your judgment, you have a judgment, you are a creditor. And you can register in the United Arab Emirates and Dominican Republic. And at that point, collect the certificates in those jurisdictions. Of course, the certificates have probably moved by that time. So this was a very, very debtor-friendly ruling, because it suggested that if you have an LLC, you can just put the certificates abroad. I guess it says that if you have a foreign LLC, we do a lot of foreign LLCs. If you have a foreign LLC, you can leave the certificates abroad and they're not collectible in Florida. And that was the law until fairly recently. And we'll get to that new law in a second. The JP Morgan case on choice of law was also very illustrative. So you had Arizona litigation. The plaintiff won the case, became a creditor, and said, well, we're going to go ahead and sue for certain LLCs that the defendant has, now a debtor, in Colorado. But they may have made a tactical mistake. I think it was a mistake, and we'll show you another case where it was a mistake. If you go to the jurisdiction where the LLC is formed, that judge is very likely to enforce those protections. That's a LLC in the same jurisdiction as the court. And so that's what the court did. The court said, no. These LLCs are protective. I've got the statute in front of me, and you can't get in. All you can get is a charging lien. What would have happened if JP Morgan Chase had sued in Arizona, where they got the original judgment? Now you have an Arizona court saying, look, I sat through this litigation for a year or 2 years. You're going to pay. And that LLC, which is in another state, I don't really mind. Maybe I'll do a Sabrina Barber move. I'm just going to call it an Arizona LLC, and you guys take it. Or I say somehow that there's a fraudulent transfer. I don't think the fraudulent transfer issue was raised in JP Morgan. I'm not sure it was a reactionary case, but it's interesting to see where we want to go to enforce a judgment against an LLC, trying to get to the equity or the asset of the LLC. I want to get through LLC, because I think we have got 45 minutes and 5 minutes of questions. If you have a question, just key in the question box and Tony will let me know. These are choice of law issues. This is like, where should we go? And then when the court gets the case, what law does the court choose? It's helpful to us with respect to which LLC we should choose. Arroyos is very debtor friendly. Arroyos was there was a litigation in Maine, the state of Maine, and it was involved a Delaware LLC. So there was litigation. It was moved to Alabama. I don't remember why it was moved. I think it was some kind of technical issue where one of the parties was in Alabama, but that's not the point. So the Alabama court says, we're going to go ahead and look at the case and look at the collection, but hold on. We've got a Delaware LLC. So the way the law really works is any court can, that's called the venue of the litigation. Now the venue is in Alabama. Any court can look at the law of another state or another country. They can look at the Delaware LLC and say, okay, the Delaware LLC says that you can't collect, or it says you can collect. Here's how we're going to rule on it. But this court says, no, it's a Delaware LLC. We're not touching it. You can go to Delaware, which is amazing. So basically, this plaintiff becomes a judgment creditor, is in an Alabama court ready to move on the assets, and the Alabama court says, no, you got to go to Delaware because that's where the LLC is formed. very, very debtor friendly. And this is a slide where we don't know which is going to govern Arroyos or Barber. Well, if you're the defendant, you're like, wow, we got to go with this Alabama court because this isn't going to work. We've got to go to wherever the LLC is formed. And that's kind of what that JP Morgan case said, that Arizona issue. If you're the plaintiff, we're like, no. Florida said that we're just going to turn whatever LLC this is into an LLC in our state, and then we're going to take your stuff. We don't know how it's going to go. We haven't had a lot of guidance on that since those cases. Here's that Sargent case, a full overview. At the end of the presentation, we can send you a copy of this if you want. This is that Sargent case where you had a judgment in Florida, and the court says, well, you know what, you can't collect, and you've got to go to the various countries where those stock certificates have been moved, which was very, very protective. But then we got in 2021 the Shim case. So, when I go over to my partner Bowman and say, look, we just had this Sargent case. Do you believe this? And he says, I don't understand. And the reason he says that is because you've got two kinds of jurisdictions. You've got jurisdictions over the LLCs of the stock, the certificates, whatever. And then you've got jurisdiction over the person. So if the person's in your court, you can actually, there's a number of cases on this, say, okay, as a court, those certificates are abroad, but you're bringing them back here. I've got jurisdiction over you, or I'm putting you in jail. Very few people understand that you can actually be put into jail under civil contempt. It's contempt of court, where the court can put you in jail. It's not a crime. It's just that you need to bring these assets back so we can enforce our judgment, or I can put you in jail. Now, you can't put the person in jail forever. It's only until you could reasonably expect that it would cause them to produce the asset. I think it's very controversial, the whole thing. But anyway, the Sargent court says not doing it. Now, Bushell said, but the Bushell versus Shim, what he did is he got subject to a judgment. He had a sale of his company. He took the asset and he converted into kind of a Korean type. It's like a CD kind of thing. And then he kept the CD in Korea. I think he also pledged it to the bank somehow. I don't think we want to get into like Korean finance in the seminar, but it was the same idea where the asset was in another jurisdiction. So under Sargent, the defendant could say, well, look, it's not here. You can't collect. You've got to register your judgment in Korea and collect in Korea. And the lawyers for Shim were like, look, there's just existing precedent and law that says, court, you can hold Shim. You can hold Shim in contempt until he brings that back. And the court said, no, I'm going with Sargent. I'm not going to do a thing. That's the law. And there was an appeal. And on the appeal, it got all the way to the Supreme Court of Florida. The Supreme Court of Florida it's kind of both opinions, both the appeals court and the Supreme Court are kind of funny in that they're like, well, there's no law on this because the power of the court over the individual to bring the assets back is totally obvious. They're quoting cases from like 1892 and so, because there is no precedent. It's just so clear. Very rare you come across that. So the Supreme Court said, no. If they're in your court, you can put them in jail until they bring back the stock. So much for the debtor-friendly case of Sargent. Here it is, the reversal, and then it went to the Supreme Court. A trial court may compel a debtor to turn over property abroad. And then we get into the single member LLC. So what happened with the single member LLC is that early on, I think it was the late 90s, the bankruptcy court said, well, Ashley Albright, who was a movie star, you owe a lot of money. And what we've decided to do is discharge your debt. So now you're in a totally different court. You're in a bankruptcy court, and they've given you the benefit of discharging your debt. So, the door is open. And they said, well, got these single member LLCs. And I know Colorado, it was Colorado. Colorado says they're protected. Well, whatever. They're single member, and the idea of protecting an LLC, what came from partnership law. And the idea in partnership law was that if someone sued a partner, they could only get a lien because you couldn't impact the other partner. The idea was there was only a lien because if you took the stock from the one partner who owed the money, the other partner was impacted. None of this is in the LLC statute. It has nothing to do with anything. But the bankruptcy court got there because they had discharged all her debt. And so now we have this innocent member argument, which opens up all single member LLCs. We had a number of bankruptcy cases that adopted that. And then you had a Florida case, finally, it was years later, where he had a bad actor, a real criminal who did a credit card scheme, got sued by the FTC. And the case wasn't a regular case. It was certified to the Florida Supreme Court, which means we have this wild question. Can you guys give us an answer? And they did. So what they did was they said, the Supreme Court, well, the LLC is really kind of like a corporation. I know it says all this stuff about charging lien and protections, but it's kind of like a corporation. So where there's only one member, it's completely exposed. And by the way, we think that the multi-member equity may also be exposed. So all of these huge businesses with LLCs kind of freaked out, and like 25 lobbyists went to the state, and including the banking lobby. So they went to the state, and then they redid the whole statute just to get around Olmstead, but they still exposed a single member LLC. The banking lobby got that. It's still exposed, substantially exposed. So we really try to stay away from the single member LLC in Florida. That's Olmstead. And I had mentioned some of the states protect the single member LLC, Nevada, Delaware, Wyoming. Wyoming has a tough case, which has moved everybody away from Wyoming. So now we move into, well, if it's not a single member LLC, but it's kind of like a single member LLC, so we can enforce our judgment. What is it kind of like a single? Single member LLC, so it doesn't really count. And so we go to California, because California always pushes, almost, you can go to bankruptcy, but it's really different rules. But California, this was not a bankruptcy case. They'll push the envelope. This was a case, it was almost a perfect fact scenario. You had a very wealthy guy, Baldwin, with basically this Andromeda strain family holding structure. There's a default. Kirchie wasn't paid. Real elaborate litigation, and then Kirchie says, "Well, look, I need to get to these LLCs. This is ridiculous." It was real flagrant, and Baldwin's attorneys say, "No. The holding company is 1% owned by the wife." Well, yeah, I mean, this is the case kind of we were looking for, to tell the clients, like, you can't just put 1% in your spouse's name. You can do TBE, tenancy by the entirety. You can add trust for the kids for 5% each, or what, that might work. That likely will work. We don't know yet. But you can't just say, I own everything, but my spouse has 1%, and I tell her what to do, or him what to do, whatever. So in California, they had a rule that said that with corporations, this idea of breaking through a corporation to get to equity doesn't apply. So it created kind of a confusing set of cases. It doesn't apply because it's completely inappropriate. Corporations are not protected from the outside. So what had happened with Baldwin now is they're thinking about a charging lien. They're going to get the charging lien, right? And then Baldwin says, well, I'm not going to make any distributions. He had distributed $178 million before that, but now we're not going to make any distributions. So basically for this small debt, he exposes his whole structure, which was pretty exposed to begin with. And so it goes up to California appeal. And basically the court recognized the idea that the existing law applied to corporations to which it was not applicable. So they first said, well, this idea of piercing from the outside and getting to the assets doesn't apply to corporations. So those cases preventing it don't apply. And so what the court said basically was, you really don't have another member. So we're going to allow you at the trial level to break through the LLC that's 99-1. So it's somewhat insightful. It's somewhat insightful. We really would never recommend a 99-1 scenario, but it's interesting to look at it and to see, okay, now that we have 99-1, at what point is that expanded? Who really needs to be an owner? How much do they have to own to have a multi-member LLC? And interestingly, also, when you get into these cases, you have to have the right lawyer. We were looking at this, and there was no discussion of the fact that this was a Delaware LLC. And Delaware says, even if you're a single member LLC, you cannot reach through the LLC. You can only get a lien. I think the court would have ignored that anyway, but it's interesting. It would have been interesting to see how they handled the single member situation. Many other courts actually just follow the black letter of the law. Many civil courts do. The bankruptcy courts tend not to, because they can work on public policy because they're discharging indebtedness. This bankruptcy court, though, in North Dakota, faced an issue where someone was trying to break into a trust. So in other words, with a corporation, you take the stock. With an LLC, you can just get a lien, but you're trying to break in. If, for instance, it's a single member. A trust is different. I mentioned that at the beginning. A trust is a different party with different titling. The court said that doesn't work. That was refreshing in a way. That was debtor friendly. They just kind of dismissed it as silly. The idea is create all of these things in the most protective jurisdiction before you have problems. And then you don't get into this fraudulent transfer issue. You don't get into this 99-1 single member issue. And you take away the arguments of the creditor. And it's powerful. Here I mentioned we add children for members, hoping that'll work. We use a lot of offshore LLCs. The offshore, I had a hand in drafting one for the Nevis, the country of Nevis, a small island. All of the protections, all of the single member stuff, all the fraudulent transfer issues, all the statute of limitations are heightened there. They're all very heightened protections. And so it's very protective, but the idea is not that you have the money here. If you use a foreign entity, or a trust, you want to keep the money abroad. We deal with some very fine financial people abroad, and obviously that's not applicable to every client, but it does come up a lot. Here's the Barber case, which confirmed that you don't want to keep assets here. They're just going to grab the assets if at all possible. And you don't want to be here, or your manager or your trustee. If your manager and trustee aren't here, and you're not here and your money's not here. You could be here actually with a trust, but if the trustee's not here and the money's not here, the court actually doesn't have jurisdiction over the assets. You can talk about all of these statutory protections all day, but that's the crux of it. It's just hard to reach that stuff. We had talked about if we run into problems with a single member, or we have an asset maybe that can't be put into an LLC, we do tenancy by the entirety. We do husband and wife. If we have a Florida issue or Delaware issue, they allow for that. It requires a case against both husband and wife, a judgment against both husband and wife before the asset may be reached. So then we get into, you know, if we have a single person and we have an LLC, a family LLC, well, the single person is still subject to lien. We sometimes can avoid lien by that person forming their own trust in one of the 18 jurisdictions that allow you to form a trust that's protective. And so when push comes to shove and when you get into litigation, remember that's a significant cost to the plaintiff to try to break through a statute that says, look, if you put this into your own trust and you have the trustee in Nevada, that asset is not available, no lien. It's a great idea. There's no drawback to it. It's just that there's a number of cases which we'll get into in a second here. This goes through the type of trust. Revocable trusts are worthless for asset protection purpose. Special purpose trust, this type of thing. And then which are trusts are generally for other people. I create a trust for someone else for estate planning purposes or because I don't want them to touch it. Those are all very protective. Asset protection trust is a trust I create for myself. You can't do that with a Florida trust. You've got to go to one of these 18 asset protection jurisdictions in the States or abroad. The domestic is cheaper, it's more convenient, but you have to be careful. It's not as protective for a number of reasons, but the full faith and credit clause of the U.S. Constitution says if I have a judgment in Florida, I can register it in Nevada. Does that work all the time? Not really. We've defended that. So you have your judgment in Florida, but it's against grantor. Grantor is not a beneficiary. In some cases, is a beneficiary, but is not trustee of this trust. You don't have jurisdiction in Nevada. We've won those cases. The foreign trust is phenomenal. If your assets are abroad and your trustees are abroad, very hard to break through that. And I said only 18 states. I'm coming up on a hard break in a few minutes, so I just want to see if we can get through the slides. A lot of these domestic asset protection trusts are untested. We've got some very colorful cases. The Uber case was bankruptcy. Of course, when you get into bankruptcy, you know, you can throw a lot of the rules out the window. Essentially, if you go bankrupt, the bankruptcy court's going to see if there's a public policy reason for not enforcing the trust. And if they find the reason, then they just ignore the trust. Or what they say is, no, you didn't form it in that one's Alaska. You formed it in Washington State. Washington State doesn't protect it. You're out of luck. In this case, it was a developer who had essentially no connection to Alaska. I mean, he did have an Alaska trustee, co-trustee, but all the assets were in Washington State. He was in Washington, did business in Washington State. The moral of the story is you've got to comply and create a connection to the trust and don't go bankrupt. Mortensen was kind of just a funny case, funny for us, not for him, where he had created his own Alaska asset protection trust. Because he was from Alaska, it was likely enforceable, even though he did it himself. But he basically moved everything in, and then 4 years passed, so he was past the state statute of limitations on fraudulent transfer. The wife couldn't reach anything technically. He files bankruptcy, which opens up a 10-year statute of limitation, and he loses the assets. It's absolutely crazy case. Trustco was a pretty interesting case. The upshot of Trustco is if you're doing this protective planning, based on the fact that the idea is that if you later run into trouble, you've done the planning, you're all set, the assets can't be reached. You want to tell, if you have a current lender, you want to make them aware of the planning. That starts the statute of limitations. In the Trustco case, Trustco was made aware. How they were made aware, I don't know. Oftentimes what we do is we send a letter to the lender. And then tick, 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 4 years passed. They had a default, but there was no way to reach the assets because the time had passed. They also went to a Delaware court with a Delaware LLC, which is a no-no. Delaware is almost always going to find a way to enforce their entities. These are some technical cases. A lot of the self-settled trusts in the states require very specific funding requirements, like financials and certain affidavits. You want to follow those, because if you get into trouble, the technical pieces will be brought to light, and it may expose the trust. Kilker was the case that basically says you did your planning, everything's safe. He had built pools, and many years later, the pool's foundations kind of cracked, and he got into trouble. I don't know why he would even be liable personally for that, but he really baited the court. And the court said, I'm throwing all that out. I don't care about the statute of limitations, and went after the trust assets. It's an outlier, but it's always a good idea to get everything buttoned up and go in good faith if you get sued. There's some of these other cases that show how the courts reach into trusts and LLCs. We talked about Barber, where you don't want to leave the assets in the U.S. is because the court's just going to call a Nevis LLC a Florida LLC. Rush University was an interesting case. It involved a foreign trust that benefited, just basically survivors of the grantor, and the grantor had committed to substantial money going to a medical center, and sued because they had relied on this money coming in. Apparently the estate didn't want to pay it, and the court's basically going to find a way to get the money to the medical center because they relied. And what they end up doing is there's a line of cases called the Portnoy line of cases where they say, well, in light of public policy, we know it's a foreign trust and we can't get into it, but we're going to call it an Illinois trust, and some of the assets are here, so we're going to take them. It's just another example of going in good faith into these situations. If grandpa pledged the money, you're going to have to give the money over to the university. And then you have excess control and alter ego, which is basically you've got to respect the formalities of these things, the LLCs and the trust. If you just treat them like your own piggy bank, it's not going to work. Courts will just look through it. That's very, very, very trodden in a number of different areas. You just can't do that. These are factors to alter ego, where you just kind of abuse the formalities of the structure and treat it as your own. And then shams is like you're using a trust for a bad purpose. You control the whole thing, and it's like to keep some kind of money aside, but it's not real. Similar to alter ego, and that's this Bilzerian case. And have to keep in mind that in any case, once there's a judgment, the court can use this civil contempt to threaten to put you in jail if you don't disgorge the asset. We've got a couple of cases. Interesting that Affordable Media, they sat in jail for 6 months. They didn't really give up much. And in Lawrence, he sat in jail for 6 years. It was bankruptcy, and settled, kept the assets, because you're not allowed. It's not prison. You're not allowed to keep people in there forever. You can argue that it's impossible for me to get to the assets because I put them in a foreign trust and it's a foreign trustee, but the courts don't go for that. If you set up the trust, you can't argue that the trustee's not gonna pay it out. We're Forster Bowman. If you want a copy of the presentation, or you'd like a copy of my books on asset protection or the estate and gift tax and the non-citizen, just let us know. We appreciate it so much that you attend the seminar.
Gary, we have one question.
Sure.
In Florida, single member LLCs are protected or not?
Well, it's a great question. So they went through this case, Olmsted, and they reacted to Olmsted, the legislature, by creating a new LLC statute. So what they did was they went ahead and protected the multi-member LLC. But I think it's the only statute like this. It's definitely the only statute with this kind of detail. And it says, but with a single member, it can be foreclosed. It might as well be a corporation unless distributions coming out are likely. I know it's it's kind of a ridiculous statute, but basically what that means is it's totally exposed unless this is something where someone gets a charging lien on the equity and it's in a public LLC or something like that, where the monies are going to come out to the creditor anyway. It essentially never happens. So the answer is, yeah, it's exposed in Florida. The single member LLC is exposed. Appreciate you attending.